Hi everyone. So today our group would like to present a case regarding our topic Volenti in non-fit injury. So our group had choose case Teh Wasong and Chop Di Chimu and another. So let's start.
The case detail of Teh Hwasong and Chop Lim Chin Moh and another 1981 is the plaintiff was a passenger in a lorry driven by the defendant. The lorry involved in an accident and the plaintiff sustained injury. In this case, the lorry's owner, not the driver, claimed that there was a notice in the lorry states riding at your own risk, and so claimed defense of voluntary. In this case, the defendants failed to invoke that defense of voluntary because the court doubts such notice was brought to attention of the plaintiff. The court further held that in order to succeed, the defendant must give sufficient notice to plaintiff about the risk.
Now, moving on to the facts of the case, first of all, it was a common ground from both parties that the plaintiff was a passenger in a motor lorry number NCN527 owned by the first defendant, and it was driven by the second defendant, who is the servant of the first defendant. Secondly, on behalf of the first defendant, it revealed that the second defendant was notified by the first defendant about 2 weeks before the incident date that he should not allow another passenger to be with him. Thirdly, in Lim Ki Tian testimony, which is one of the first defendant partners, he stated that riding at your own risk label was affixed in the driver cabin of the lorry, and it was said that the label was in English and that the notice stated riding at your own risk. However, in evidence, the second defendant insists and alleged that the label was in Bahasa Malaysia and it was authentic penumpang dilarang. Last but not least, as a result from the accident, the plaintiff had suffered a hematoma from the left thigh, abrasion over the left forehead, the left forearm, and left loin. And last but not least, the fracture from the lesser truncator with a spiral fracture of the shaft of the left femur. As the result from the injury, the plaintiff had a great difficulty in walking as he not able to squat, and the plaintiff had suffered stiffness on the hip, knee, and ankle, from which it is very unlikely that he will recover. Now, I shall pass the floor to the next person to tell to us about the issue.
So the next part of this case is about the issue. So the first issue is whether the plaintiff had voluntarily and freely with full of knowledge of the nature of the risk to raising the defense of voluntary non-fit injury. So the defendant claims that the plaintiff is aware of the risk to prove the defense of voluntary. The plaintiff requested a ride with the second defendant to accompany the oil palm fruits being delivered to a factory in Kluang. The first defendant claimed that the plaintiff had been told by the second defendant that he was riding in the motor lorry at his own risk, and that the plaintiff's attention was drawn to a label attached near the passenger seat by the driver said that seat, riding at your own risk. It was also noted that first defendant did not raise the argument that the second defendant had let the plaintiff travel in the motor lorry against the first defendant restriction. So to be precise, that the defendant believed the plaintiff is voluntary and freely with full of knowledge of the nature of the risk. Next, the second issue is about was the accident caused by the second defendant negligence. So the second issue is about whether the second defendants are breached his duty of care and caused a negligence. So the lorry, according to the plaintiff, is fully loaded with large quantities of oil palm fruits. The second defendant abruptly swerved the lorry to the left, causing the lorry to overturn as it traveled on the side table, which was lower than the level of the road's metal surface. The second defendant, on the other hand, contends that he was not negligent because something occurred while he was driving and the lorry was overturned. So The plaintiff received major injuries as a result of the accident and he filed a claim for the defendant's damages. So based on the issue, we can refer to Dan and Hamilton case, where it's the same situation about a passenger being hurt in the accident caused by the defendant negligence. So the fact of the case that the defendant was drunk and the plaintiff still boarded the vehicle. However, the health said that Volenti did not apply because the plaintiff did not give consent or agree to exempt the defendant from the negligence that occurred thereafter. So we can conclude that the voluntary cannot be claimed because the plaintiff not voluntary and freely be full of knowledge of the nature of the risk.
Next, we'll be talking about the plaintiff arguments in this case. The plaintiff deposed in evidence that the lorry was fully loaded with a large amount of oil palm fruits while it was traveling on its way to the factory about 3:45 p.m. on January 11, 1975. The second defendant suddenly swerved the lorry to the left and traveled on the side table, which was lower than the level of the metal surface of the road. When the second defendant swerved back the lorry onto the metal part of the road, the lorry overturned. When he asked for a lift from the second defendant to accompany the oil palm fruits to the factory, he was allowed to do so, and he was not warned that he traveled in the lorry at his own risk. Now we'll be talking about the defendant's argument. The defendant stated that on that material day, it was raining heavily. About 3/4 milestone Jalan Cha'ah backward while the lorry was travelling downhill. The second defendant saw a lorry approaching from the opposite direction. As the oncoming lorry came nearer, the second defendant noticed that the oncoming lorry encroached on his path, and so he swerved to the left onto the side table. According to the second defendant, there was a drain in front of him. He had to swerve to the right to avoid landing into the drain. When he did so, the lorry overturned. In cross-examination, the second defendant said that the oncoming lorry was a small lorry, and when it came close to second defendant's lorry, it had gone back to its correct side of the road, though earlier it had encroached onto his path.
Next is judgment. The plaintiff was 53 years old at the time of the injury and is predicted to continue living until he is 65 years old. The plaintiff's longevity is set at 12 years. 1/4 of it would be deducted for the future contingencies by the court. As a result, the multiplier would be based on 8-year purchase at $300 each month. 8 times 12 times 300 equals to 28,800. Lastly is the court's decision. The accident was determined to be caused by the second defendant's negligence while driving. As a result of the plaintiff's injuries, the court granted her a total of $20,000 plus 6% interest from the date of the writ to the date of judgment.
So that's all from us. Thank you.